dado, então, o segundo bom dia, né? Saúdo novamente. Vamos dar início, então, agora à nossa aula, né? Do curso sobre Direito Constitucional Europeu e Alemão, né? O grupo de estudos será na sequência, né? Mas hoje nós temos mais um convidado ilustre, né, da Alemanha, contando também com a participação do professor Fabiano Menck, né? Sabe que é um parceiro nosso de toda hora, né? E que inclusive eu agradeço porque Fabiano fez a intermediação nesse caso, né? Para a vinda do participação conosco aqui, vinda futuramente, né? Pessoal do professor Gerrit Hornung da Universidade de Kassel, né? Que o professor Fabiano conheceu, né, Fabiano, quando estávamos lá fazendo doutorado com o professor Rossnagel, que era na época o capo de capo, agora é o professor Hornung, né, na cátedra onde também se trabalha com proteção de dados, né, como uma das ênfases, né, mas o Fabiano depois vai fazer a apresentação. O professor Hornung vai falar em inglês, como nós já sabemos, né, uns 40, 45 minutos, depois nós teremos tempo para algumas observações minhas do Fabiano e abrir para discussão. A professora Laura Mendes, que tinha sido convidada a também atuar como debatedora, né? Ela não pode, aliás, eu também não poderia, mas evidentemente aí priorizei essa nossa atividade, pedir desculpas, né? Embora fosse também a primeira reunião, porque nós temos uma comissão, um grupo de trabalho do CNJ, que foi montado para trabalhar na conversão da LGPD para uma regulamentação para o Poder Judiciário, e marcar a primeira reunião para agora de manhã às 10 horas. Né? Então, evidentemente, eu fiquei aqui, né? E a professora Laura ficou lá, e pede desculpas por isso. Tá bem? Professor Hornung, please be welcome. It's an honor and a really for us to have you with us to talk about the right to be forgotten. And I immediately give the word to our common friend and colleague, Fabiano, for your presentation, and then following with our proceedings.
Professor Ingo Sarlet, thank you. It's an honor to be here today with a colleague of ours, a friend, more of that, he's a friend of ours from Kassel, Professor Gerrit Hornung. I must say, I know him for 15 years or more, a little bit more maybe. It's been the first time that we speak in English, so that's a challenge for us, for me maybe. He speaks all the time in English there, in Germany, in Europe. And I wanted to introduce Professor Gerrit Hornung, saying that, first of all, he was born in Kassel, so the city in the middle, the center of Deutschland, of Germany, in the state of Hessen, where Frankfurt is, and where the first act, the first law in the world about data protection came into force, was in this state. You know that, and so Gerrit was born there in this state, in the city of Kassel. He also studied law and philosophy in Freiburg. This is a very traditional university in Germany. He made afterwards a LLM, so a master's in Edinburgh. 2 years he was there. He made then his PhD studies in Kassel, at the University of Kassel, with Professor Rossnagel. Professor Ingo already mentioned his name. Professor Rossnagel was Gerrit's PhD advisor, and he was also my PhD advisor. And during this PhD time in Kassel, I had the chance to meet Professor Hornung. It was a pleasure. We stayed together. A lot of, many, I would say, PhD students, under the supervision of Professor Rossnagel. And today, Professor Hornung is the follower of Professor Rossnagel in this Lehrstuhl, this chair of public law in the University of Kassel. He was, before Kassel, in Passau, that's south in Germany. He was there a professor, also for IT, information technology law and all this matters connecting to IT law. He has many publications. I'm just gonna show you here one of them. These are the commentaries of the GDPR. He wrote this. It's with the legend in the subject, Simitis, and Indra Speaker will be here with us, if I'm not wrong, next week or in the following weeks. And he has many other publications. Yeah, I saw that he has also commentaries on the GDPR in English that are coming in the end of the year. He could maybe speak a little bit about this afterwards, but this will be very nice because, you know, we all know how German is difficult, and if we have these commentaries of the GDPR in English, this should help us a lot by understanding more and more this very important rule. So, Gerrit, I'm very honored to have you here today. We are honored that you're here today. We are honored that we have the University of Kassel here with us, a new and very young and very specialized in these subjects of IT law. And it is our pleasure to hear you now about this very important subject of the right to be forgotten, and very interesting in the perspective of Europe and Germany. So this would be a very interesting opportunity for us here to hear you, my friend. Gerrit, you have the word.
Well, thanks a lot for the invitation, first of all, and to both Professor Salet and to Professor Menke. And yeah, good morning in Brazil. Here it's past lunchtime, actually. I've had my lunch already, but I think for you it's still in the morning. So good morning, everyone. And thanks for this warm welcome and introduction. I don't have anything to add by myself. I can just say that I'm really honored to be part of this lecture, all the more now that I know how many distinguished colleagues you invited already and you're about to invite. So let me just share my screen with you and see how I'm getting organized to see at least a couple of your faces still. So now you should be able to see my screen now. Fabiano asked me to talk about the right to be forgotten. And I'm going to do so on two perspectives which are sort of intertwined, namely the European and the German ones. So this is my outline. I'm going to give you a bit of a background to what we understand as the right to be forgotten. I'm going to talk a bit about systematization. I then give you still as a background, if you want to put it like that, the famous Google Spain case, of which I assume at least some of you may have heard already, because this has been the landmark of the data protection law discussion regarding the right to be forgotten in Europe. But it was so far-reaching that this case has been hotly debated way beyond Europe. It has been debated in the US and probably in Brazil as well, I assume. The main, and maybe for at least most of you, new developments are then following, and those are two cases, both by the ECJ and by the German Bundesverfassungsgericht from autumn 2019. So there were two important cases from Europe and two important cases from Karlsruhe by the end of last year, and they concern specific aspects of this right to be forgotten as regards sensitive data, the territorial scope, and the relationship between the responsibility of the owner or the operator of the website on the one hand side and on the search engine on the other hand side. The results will be intermediary. We don't have any final remarks on this right to be forgotten. Okay, so just to kick off then, who wants to be forgotten? Maybe you might think, well, this is a debate for some people doing evil or doing wrong on the internet or somewhere outside, but just to, for the sake of the argument, assume that you had Googled me before I gave this talk, okay? So this is the Google screenshot from yesterday when I prepared for this talk. So just assume for a second in the middle, you wouldn't have found this link here, but another link. Okay, I made this up. Yeah. Okay. So you would have looked this up and you would have read to your surprise that Gerrit Hornung has done something evil a long time ago, which has absolutely nothing to do with the talk he is giving today. What would you do? You would click on the link. What would I do? I would try to protect my reputation by getting rid either of the content of the original website or by at least blocking Google from showing this link to you. Okay, so this is the basic constellation, and it works all the more the further the distance between the original evil in this case and the case at hand is, okay? Because this is why I wrote this there. It has nothing to do with what I'm going to do today, with our relationship towards us. It's something way in the past, and still it appears on the first Google page when anyone, including you in my professional surrounding, Google me, okay? So I would like to protect my reputation, and I'm not the only one. And Europeans are not the only ones. When I give this talk or talk about this in Europe, I usually take examples from Germany or from Europe. But this is from the beginning of the year in America. So even in the US, there's a majority of people who want, as the quote here is, to be able to keep things about themselves from being searchable online. Okay? So this apparently is a basic human need to at least have some sort of control about what others find about you on the internet. So if we step back for a second and have a look at the roles which are sort of which interact here, and then obviously ask what this right is and what it could mean, because it could mean different things. We first of all need to keep in mind that we have some sort of three-step information model here. We have a layer of information providing, we have then a proxy sitting in the middle, and we have a layer of information seeking on the other hand. So who is providing information here? There are different roles here which could merge together as well, but which should be separated from a legal point of view. So we do have what we call in data protection law the data subject. That would be me in that case, okay? The person whose personal information are put or shown on the internet. We then have an information producer. That's somebody who actually puts the content on the internet, on a website, and we have the website operator. And these three roles could all be the same. In the case I run a personal website about myself and I put content about myself on my own website, then this becomes all one. But it could also fall completely apart, because if somebody of you posts on his Facebook account something about me, then I'm the data subject, you're the information producer, and Facebook is the website operator. And so there are, even on the information providing side, there are different legal claims and legal interactions. On the other hand, on the information seeking side, this could basically be everyone. And this makes it all the more complicated, because this could be a journalist trying to write a story about me, being protected by freedom of the press. This could be commercial players trying to show me some sort of personalized advertisement. This could be state agencies trying to find out if I'm a criminal. And it could be private persons like you, just because you run into a talk of mine in your postgraduate course. So all these interact, and in the middle, there's the search engine thing. And in the middle of this information model, we see a new actor, because most of the other actors were there before the internet. There wasn't website operators, but there were media producing information before the internet. But this proxy question is new, and this is the main reason why we talk so much about this issue here. So what do we actually mean if we talk about a right to be forgotten? This may mean very different things, and it may relate to different branches of law. I give you at least one example from another branch of law, and that is fundamental rights. So if you think about cases where somebody wants to be forgotten, then this could also happen in the pre-internet world. And we have actually famous fundamental rights cases in Germany there. Some of you who studied German law may remember the Lebach case. Lebach was a famous case of murdering. There was a murder happening in front of a military base, and there was lots and lots of press and media naming the actual suspects. And they sued against this being named, and the Bundesverfassungsgericht said in this first case back in 1973 actually that this was legal because the case gained so much of public interest. And after several years, after decades actually, the two convicted murderers got out of prison, and the German ZDF, the German television, made a film about them, about this famous case, which was decades ago, again naming them with the actual names. And they sued again, and this time the Bundesverfassungsgericht actually accepted this claim and said, well, they must not be called by the actual names because of the right to social reintegration, which is part of human dignity according to the jurisprudence of the German Bundesverfassungsgericht. So this is a rather old idea that your name should not be, you should not be connected with some sort of crime for the rest of your life or other things which shame you, for example. So you can see here already that this is a German view. If you try to explain this to an American constitutional lawyer, this would be a completely different view. And obviously in the time of the internet, this becomes complicated because there are media reports in other parts of the world and then on the internet where this name still can be found. Right? And the press interacts very differently nowadays. There was another case of a convicted murderer of the German actor Sedlmayr, who tried to make the New York Times deleting his name from its press archive. And what the New York Times did was they made a new story out of this, putting it on the first web page of them, saying, well, this convicted murderer in Germany wants us to delete his name from our press archives. This is in violation of freedom of expression. So here again is the picture and the name of this convicted murderer. So this sort of may backfire as well, an effect called the Streisand effect. If we look at this from data protection law point of view, then the right to be forgotten again may mean different things. So it could be a right to erasure of personal data from websites or from databases actually. And this right to erasure has been part of data protection law since the 70s actually, since the first law of Hessen, which Fabiano just mentioned already. It could also mean a right to have others informed about a claim to have data deleted. This is what's actually new in the GDPR. Article 17, paragraph 2 says that if somebody processes data about me on the web, I rightly claim deletion of this data, then he is under an obligation to inform others who may have processed this data that I claim deletion, which can be impossible on the internet because the owner of the website would not know who got the data from that website. But at least there is this hint that this could be part of the right to be forgotten as well. In practice, however, practice has shown that this right of erasure is not the main focus point of the discussion. Rather, it relates to a right to be delisted from search results, from search engines, maybe a right to hold, to hide old articles in online archives, or to even update old articles, particularly again in criminal proceedings, because if somebody gets acquitted in the later course of that proceedings, he may want to get these old articles where it still was a suspect to that crime to get updated. Okay, so we need to keep in mind this, that the right to be forgotten may mean different things. Coming to this landmark decision of Google Spain, for those of you who are not familiar with the case, back in 1998, there was a notification in the Spanish newspaper La Vanguardia by the Spanish Ministry of Social Affairs, and they announced that several real estates would be sold by court order because the owners of that real estate did not pay the social insurance fees. They were employers, basically. So one of the owners of the premises was the plaintiff of the national court proceedings, Mr. Gonzalez, who is, by the way, not forgotten, but he's now equipped with his own Wikipedia article, and you can still find his name and his picture on the internet. He won the case, but he's not forgotten at all. But obviously that's a side discussion here. So Mr. Gonzalez asked the National Supervisory Authority to issue orders against both the newspaper and against Google. And he was successful only against Google. Because the Spanish Supervisory Authority said, well, the newspaper may still store and provide these articles because of freedom of the press. So Google then sued against this order of the supervisory authority to the national court, and the national court referred the case to the ECJ. For those of you who are not so familiar with European Union law, there's an obligation to do so for courts of last instance, which is not the case here, but also the possibility for every court to do so, to refer the case to the European Court of Justice if the case at hand requires the interpretation of European Union law and the question is not already decided and solved by the court. So what were the key results back then of this Google Spain decision? The first question was, is that a data protection case? Is data protection law actually applicable to this case? And the ECJ said, yes, it is. Simply applying data protection law. Oh yeah, by the way, here on this slide and the further slides, I give you the GDPR articles. So the case was decided under the old data protection directive, but the provisions I put here on the slides are more or less still the same in the GDPR. And as I don't want to bother you with the old law, I put the new numbers in here, even though that was not the applicable law back then. Okay, so A, is it personal data? Well, obviously it is personal data. It's an information relating to an identified natural person. Is it processing personal data? Well, yes, it is. But because what does a search engine do? It runs through the web. It indexes personal data from the web. And if I put in a search term, then this index is being searched. I mean, Google doesn't run around the internet once I type, they just search their index. So this is processing of personal data. Who's the controller? So who's the one responsible for the whole thing? Well, there's a definition in the GDPR and says the controller is the one who determines the purpose and means of the processing. Who is that here? Well, that's Google for the part of the search engine. Obviously, there's also the website operator. There's also the information seeking side. Everyone is processing personal data here, but who's the one responsible for the index, for searching the index, and for putting information on the website, on the search result page? Well, that's Google. I must say, however, that the Advocate General, the person preparing the case within the European Court of Justice, had taken the other side here because of everything that is now going to follow. Because he had already had a glimpse in the future and said, well, this is going to get you in trouble. If we claim this being a data protection case, then we're going to have lots and lots and lots of problems. And he was right. We're going to have lots and lots and lots of problems because of this decision. But that necessarily doesn't necessarily mean that this decision is wrong. Okay, so I would still think it is a data protection case actually here. There was another problem there, which is actually not problematic anymore, and that was the applicability of Spanish data protection law. That's old law. I just put that here for the sake of completeness. In here, I'm not going to talk about this anymore because we now have the GDPR being applicable uniformly. So First result, this is a data protection case. Second result, the rights to erasure and to object apply. And without getting too much into details of data protection law here, this then comes down to the lawfulness of processing. So you have a right to erasure if the processing of your personal data is unlawful. And lawfulness of processing has an own article, Article 6, with the different types of consent, for example, is one of the main things, a necessity for the performance of a treaty, a legal basis in state law, and so on, and which doesn't help the search engine here. What could help is the last one, and that's the legitimate interest clause. So processing is lawful if it is necessary for the purpose of the legitimate interest pursued by the controller or, and that is important, by a third party. So not only the legitimate interest of Google, but also third parties, and that's the information seekers, except where such interests are overridden by the interests of fundamental rights and freedoms of the data subject. So we need to get to a balancing test, okay? We balance the legitimate interest of the data processor against, or third parties, against the legitimate interest of the data subject. What does the court make out of this? Well, first of all, on the side of the data subject, we have fundamental rights because we have the European Union Charter of Fundamental Rights. And in there, we have a right to private life, Article 7, and we even have an explicit right to data protection. The connection between the two is still not clear, but the court doesn't bother. It always cites the two together. It says, well, this is data protection and private life, Article 7 and 8, and it doesn't bother about distinguishing between the two. So this right is clearly affected. Is it affected severely? The court says yes. Why is that the case? Because processing carried out by the operator of a search engine is liable to affect significantly the fundamental rights when the search by means of that engine is carried out on the basis of an individual's name. So this is the main argument, okay? You don't, coming back to my example, okay? You don't Google the evil which I had done years and years ago. You Google my name. And through that, I will for the rest of my life be connected to this evil I have done years ago. I would believe that this is true. And this sort of search engine public is one of the main characteristics of the internet as a public sphere. So what you don't find on, I don't know the figures in Brazil actually. In Germany, Google has about 85% usage. Is that the same in Brazil? Or do you use other search engines?
We use Gerrit, but I would say here is very dominating. Okay. I don't have the numbers here, but it's very dominating.
Okay, so that's the same in Germany then. So so what you don't find on Google doesn't exist. Actually, what you don't find on the first 3 pages doesn't exist. So ask yourself, when have you looked up more than 3 pages of Google results for the last time? More than 10? Maybe if you write a PhD thesis and you really need to dig into a topic, then you may access more than 10 result pages. More than 50? Never. Never. So, and more 50 pages, that's 500 websites which Google gives you, and that is the web. So what Google doesn't show you there simply doesn't exist on the internet. Okay? And so this is the power and obviously the risk for personality rights at the same time. Okay, so that's the data subject side. We then have the side of Google, who's doing business, and business is equally protected by fundamental rights. We have freedom to conduct a business. It's very interesting and very disturbing at the same time that the ECJ doesn't mention this article. It just spends half a sentence on the side of Google here and says it is clear that it cannot be justified, the data processing, cannot be justified by merely the economic interest which the operator of such an engine has in that processing. That may be true as a result of the balancing. I find it a bit disturbing that it is so neglected in this complete balancing test. So then we have the information seekers. And here it's even more disturbing that the court in this judgment, 2014, doesn't even mention that freedom of information is equally a fundamental right. So this becomes now a slippery slope, because they put so much emphasis on this data protection fundamental right that we need counter arguments in this balancing test. And if we don't mention that the conflicting interests are equally fundamental rights protected, then we get down this argument very easily. Okay, and so this is what the court actually does in that case. Another quote here: removal of links from the list of results could have effects upon the legitimate interest of internet users potentially interested in having access to that information. And because of that, a fair balance should be sought, in particular between that interest, I would argue between that fundamental right, and the data subject's fundamental right under Articles 7 and 8 of the Charter. I have to add that in this recent judgments of 2019, the court did actually mention Article 11. Okay, so apparently they realized that this gets a bit one-sided here. So what are then the criteria for this balancing test? The general line is what I just told you, namely that it is a bit one-sided. The court starts off this balancing by saying that whilst it is true that the data subject's right protected by those articles also override as a general rule that interest of internet users. While it overrides as a general rule, there may be exceptions, and then there are exceptions, but this is the starting point, okay? So the court claims that the personality rights, the data protection rights, generally overrule the rights and interests of those seeking information. So this could be the end of the balancing test maybe, but the court takes this as a starting point. So criteria for the balance and for exceptions are then given by the court. So one of the criteria is the nature of the information and the sensitivity. So the more sensitive the data is, the more right the data subject has to have it delisted. The time lapse is the next thing. So accurate data may in the course of time become incompatible with the directive where those data are no longer necessary in the light of the purposes. So the longer it is ago, the easier I can have it deleted. And on the counter side, there is the interest of the public, and criteria or an argument which we are familiar with from media law, from journalist issues, for example. So the interest of the public may vary, in particular, according to the role played by the data subject in public life. And so this is where those cases of murder come into play, because the interest of the public is clearly there in cases of severe crimes. It's clearly there in cases of politicians and so on. The interesting thing is that the court also dealt with the question how this claim against the search engine relates to claims against the original website. Because as I told you, the original claim against La Vanguardia didn't go through, and this was not decided anymore by the ECJ. But still, the court argued that this claim against the search engine applies regardless of the legality of the original website. And why is that the case? Well, because the search engine's effect may be severer than that of the website. This is true, I believe, as I told you earlier, what is not displayed on Google doesn't exist. And also because the website may not fall within the ambit of the GDPR, somebody sitting outside and not being bound by the GDPR, and the website may be protected by freedom of the press. And the last one is a very interesting one, because you could well argue the opposite, saying, well, this content is protected by freedom of the press, so it should also be accessible through Google. The court puts this argument upside down and say, because it is protected by freedom of the press, because I cannot get it out of the internet, I need at least to get it delisted from Google so that nobody can access it anymore. Whether that's true and this argument is convincing, you can actually argue and debate, because this restricts obviously the reach of this newspaper. Okay, so this newspaper enjoys freedom of the press, and it's cut off part of the internet public, namely the search engine possibilities to be found. So this is this Google Spain decision. There were lots and lots of problems. The ECJ was slaughtered by Americans for not understanding how communication works on the internet. There are problems with this balancing tests, as I told you. There are also more systematic problems. The court here finds some sort of notice and take down procedure. So this balancing test only applies if you complain at Google. So Google has now this complaint page, so you can write to Google and say, well, I want to be delisted from this and that content. But to be honest, data protection law doesn't have a notice and take down procedure. So I'm going to come back to this point. If data processing is illegal, then you're required by data protection law to delete the data. So you cannot wait until the data subject complains. You're just bound to delete it yourself proactively. Okay, so there are all sorts of different problems. The biggest problem, however, was already mentioned by the Advocate General, and it came to the it came in another Google case to the court 5 years later, and that was last year. So the biggest problem of the Google Spain judgment is that the ECJ finds the solution, as I told you, on the basis of this balancing test, legitimate interest versus fundamental rights and freedoms. And the problem is that this solution does not work for sensitive data. In the technical sense, the GDPR has, as I believe Brazilian data protection law also has or will have, a special category of data which are more protected than others. And this is data revealing racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union memberships, genetic, biometric data, health data, and data concerning a natural person's sex life or sexual orientation. So this data is specially protected. And the main thing is that it cannot be processed on the basis of this balancing test. Rather, you need one of the exceptions of Article 9, paragraph 2. There are quite a few exceptions, but most of them doesn't help the search engine provider. So these three here are discussed by the ECJ in 2019. Explicit consent obviously doesn't help Google because you would have to argue that everyone who puts content on the internet agrees or consents. You may argue this, but if you put something about me on the internet, then it's clear that I didn't consent to this, okay? So consent doesn't help here. The second option doesn't help either. Data which is manifestly made public by the data subject. So I make data about myself public, the same problem. If somebody else makes data public about me, that doesn't help Google. So the last option, and that's the option the ECJ takes then, which is problematic, as I'm going to tell you, is processing that is necessary for reasons of substantial public interest, which we're going to discuss now. But as I said, the Advocate General Jeskinen had pointed to this problem already in 2014, and he was being ignored by the court. And this is very sad because it was clear that an Article 9 case would appear because Google has no chance whatsoever to exclude this sensitive data from its processing. If you run through this list, it's simply impossible to run a search engine excluding this data, particularly because the terms are interpreted very broadly. So the fact that I see a doctor is considered to be health data. Okay, so this is very broadly, and so the search engine needs to get through with Article 9. So it was clear that an Article 9 case had to come, but it took 5 years. And 5 years is a long time for a search engine operator, and it's a long time for people claiming their data protection rights. So this is the first case which I'm going to discuss here from last year. So the court first considered ways out of this Article 9 problem, and said, well, Article 9 does apply. The French court had asked if it would apply, hinting that maybe we're going to find a possibility to not apply to search engine at all. The ECJ says, no, it does apply, but it only applies, and now we are narrowing it down, it applies to the operator of a search engine in the context of his responsibilities, powers, and capabilities, which Article 9 doesn't talk about. But the court argues that they need to be capable to follow Article 9. Well, okay. Following a request by the data subject. So again, notice and take down. This notice and take down procedure might be pragmatic. It might even be the only possible approach. But the problem is that you could argue notice and take down within this broad balancing test of Article 6. Because there you can basically use all arguments which are valid for both sides. Within Article 9, where we don't see this balancing, it's very hard to introduce this notice and take down procedure. Article 9 simply doesn't have a notice and take down procedure. You need to comply with that norm. And this is strengthened by other principles. We have in principles of data protection law in Article 5, including lawfulness. And then there's the principle of accountability. So the controller is responsible for, and he needs to be able to demonstrate compliance with these principles, including lawfulness. And so to me, it's rather hard to argue that the controller may sit there processing illegally data, just waiting for data subjects to complain. Okay, so this runs counter to the general approach of data protection in Article 9. So that is really a problem. Second problem is, to my view, it's even greater because the court misinterprets Article 2, paragraph 2, litera G here. So processing is necessary for reasons of substantial public interest. First problem, does that include fundamental rights? The ECJ said, well, it does. I would argue that this is debatable. Fundamental rights are important, but are they part of the public interest? Well, depending on your personal view on fundamental rights theory, you can argue that. Okay, you can argue that they are actually part of public interest as well. But at the outset, they're individual interests. What is more important is the ECJ argues that the operator has to balance interests to comply with that provision. Necessary for reasons of substantial public interest. You could say, well, necessity has some sort of proportionality in it, so we need to balance interests here again. The problem is, I have not given you yet the full wording of that provision. It goes on to say, processing is necessary for reasons of substantial public interest on the basis of union or member state law, which shall be proportionate, respect the essence of data protection, and provide for suitable and specific measures to safeguard the fundamental rights. So this clause does not allow the search engine operator to do any sort of balancing test. It does refer to union or member state laws providing for the processing and safeguarding the data subject. And the problem is that such a law simply doesn't exist. There is no laws on union or member state or German or whatever level allowing search engines to process data on this basis of this opening clause in the GDPR. So I have a colleague in Germany who claims that Article 11 of the Charter, so information freedom of information, should be the basis in union law. But the problem is that this fundamental right doesn't provide for specific measures to protect the individual. So in my view, this is a complete misinterpretation of Article 9, the ECJ does here. The problem, however, is, and that is probably the reason why the court does that, if you say, well, this doesn't help us again, then we're getting closer and closer to the result that Google is illegal. Because they are not allowed to process data according to Article 9, paragraph 1, and so far we haven't given them any legal basis to do so. So are there any other ways out here? One could be to go back to the first question of the French court and sort of reduce the scope of Article 9, maybe on teleological grounds, what we call teleologische Reduktion in German. The problem is that the GDPR entered into force 2 years ago, and the problems of that provision were known to the legislator. So it's rather hard to argue that we should narrow it down to this extent. Second loophole could be, can we argue that search engines are journalists? Because if we do, then we have a media clause in Article 85 allowing the member states in their media laws, in the journalist laws, to allow for processing. And then we have rather broad media laws, for example, in Germany, who allows the journalists to process data, even that falls under Article 9 GDPR. So could we argue that? Well, I guess we could. There are people arguing that search engines should enjoy media protection. The problem is that both the ECJ and the Bundesverfassungsgericht have not accepted that argument and said, well, Google does provide information. It plays an important role in this information spreading in the internet, but it's in no way acting as journalists. Considering them to be journalists might also bring about other problems, the right to counter-statement like in newspapers and others. So what is a possible way out? There is actually an exception in the provision on the right to erasure. And this provision is mixed by the ECJ with Article 9 to an extent that I'm not able to follow actually. The exception, and this might again be due to this provision here actually, because this provision is very awkward. It says that the right to erasure does not apply to the extent that processing is necessary for different reasons, including the exercising of the right of freedom of expression and information. This is very awkward because in this situation, the processing is illegal either from the outset or because the data is not necessary anymore, and it should nonetheless be necessary for communication freedoms. So it is illegal, it's still necessary. And nobody I have talked to is able to really make sense out of that provision. In any case, we would need to find a convincing solution and a convincing interpretation for that provision that doesn't damage the complete system of Article 9, which I'm afraid the ECJ has done in this first ruling. Okay, I have a look at the time and see that I'm probably going to use a bit more than 45 minutes, if that's okay for you. Okay, I see nodding.
That's okay, that's okay.
Okay, so I just continue. I have 4 more slides. So the second case of the ECJ concerns the territorial scope. And this is another issue that was not decided in 2014, that was heatedly debated for 5 years and now is unluckily only part decided by the ECJ. So if we think about a duty to delist search results, where do we actually do this? So does Google have to take it out of the search engine version of the specific website where the data subject resides? So a Brazilian citizen sees Google. Is Google allowed to distinguish between the different websites and take it out of search results from google.br? Or do we need to take it out of all Google versions? So I would assume that most people in Germany use the German version of Google. just because it's a lot easier, and also because Google analyzes where you actually are when you Google and provides you with that website. But obviously it's very easy to use other versions of Google if you want to do so. So this could also mean to delete or to delist the search results in all versions accessible from a specific member states. Then you need to distinguish between the locations of the Google user. So you need to actually locate the Google user and provide him with specific results depending on the legislation applicable to that specific Google user. That obviously runs against the idea of an open worldwide internet, but at the same time, this discussion is done in many different areas of law as well. Hate speech, copyright laws, and so on and so on. Okay, so that would be a possibility. And obviously there would be the to say, well, take all engines. So I sue Google for the results other German users may see about me. And in effect, I have the right to preventing an American user using the American website of Google from seeing specific results about me. That's possible. Technically, it's probably easier than the middle solution because Google simply takes it out of all versions. But obviously, this has a huge impact on other jurisdictions. So that was again not decided in the Google Spain judgment, but in another judgment from the very same day, 24th of September last year, again from France. The CNIL is the French Data Protection Authority. So the court, after some analysis, which was not very helpful because there's simply no rule on this, claimed that there is no obligation under European Union law for a search engine operator who grants a request for dereferencing made by a data subject following an injunction from a supervisory authority or judicial authority of a member state to carry out such dereferencing on all versions of its search engine. So the court says no, there's no such a duty for the search engine operator. You may see my emphasis here. First emphasis is EU law. So what about national member states laws? Second emphasis, no obligation to do so. Is there a possibility to do so? So we're going to see further in the judgment. So first, dereferencing is in principle supposed to be carried out in respect of all the member states. So the court refrains from applying the right to be forgotten beyond the European borders, but it does apply them within Europe. So the French and the German and the Italian and the Spanish and whatever websites are all to be changed if I sue Google in my home country. So this does not only apply to Germany, but also to the other member states. You're lawyers, so the most important words in this phrase here is in principle, because if somebody writes in principle, there are always exceptions. And there are exceptions in this ruling. And the court says, well, there is a balancing test, and this balancing test may in specific cases come or lead to different results in different member states. For example, because the public interest may differ from country to country. Take again this severe criminal. The media reports about a severe crime only in Germany, but not in other member states. So this may be that there is actually public interest here in Germany and not in other member states. Which is a problem because then Google needs to decide in which member states there is enough public interest to have the information on the internet, and maybe in which countries there's not enough public interest, so we need to delete it. The court says, well, in these new GDPR, there's this interesting thing called this consistency mechanism, which is a procedure of interaction between the supervisory authorities, and the court claims that this could be a possibility to come to uniform solutions. The problem is that I'm told by quite some people who work in data protection authorities in Germany that this process is really burdensome. It simply doesn't work, and it does in no way work for single delisting requests. So this argument apparently leads to nowhere. The second problem, or the second loophole in this judgment, is that, as I emphasized on the last slide, the ECJ says, well, there's no duty to do so. And then the court goes further to allow member states, their supervisory authorities, or the courts to order worldwide delisting. So it says, well, European Union law doesn't prohibit if national member states want to do this. On the basis, again, of a balancing of interesting test, but the court just leaves it there. So nobody actually knows at the moment the conditions under which national member state laws could provide for these worldwide delisting requests. The relationship to other decisions in Europe are completely unclear. There's no harmonization approach. So one member state court may request for worldwide delisting, and what happens if another member state court says, well, this is not the case. It doesn't have to be delisted. And what appears if US court rules the other way. It's also unclear, at least to me, whether that's legal under international law, and where the boundaries could be under international law for such an approach, because as I said, we're here severely affecting other jurisdictions, other public debates, which may be severely affected according to the laws applicable in other countries. Okay, so that's the shorter but equally important second case of the ECJ. And then I have one slide on the German Bundesverfassungsgericht. The interesting thing here is that the Bundesverfassungsgericht took a somehow different approach in two rulings of last year. The court took two cases which didn't have anything to do with each other, but came to the court about the same time. So the court took them together and decided them together. And one was a right to be forgotten claimed against a search engine, and the other one was a right to be forgotten claimed against a newspaper archive. So a different situation, but the court took them together and tried to come up with a new system of the right to be forgotten. What did the court do? First, it put additional duties on press archives, claiming that the effects an press archive has on the personality rights need to be assessed, including the existence of search engines. So a press archive cannot say, well, we are just a website, and whatever Google does with our website and whoever Google brings to us and so on doesn't care. I don't care about this, okay? The Bundesverfassungsgericht said, no, when you're assessing whether or not to put personal information on the internet, you need to be aware of, you need to take into account that there is such a thing as a search engine public. So you need to include this dimension in your own balancing test. Because in the old times, in press archive was something where you needed to go into, you got big folders of paper and needed to run through them. And now there is the internet, there's Google, and we need to take this into account. So this could lead to additional duties for press archives, including, for example, technical measures to take Google out. Either of the complete press archive, so you would need to go to the archive of La Vanguardia, the website of La Vanguardia, type the name into their website and then look it up, which nobody would do. Or at least to exclude the indexing of older press articles once they're outdated. So that could be one possibility. In the second case, they put less duties, they lessened the duties for search engine operators. So the general idea is we need to put the decisive test on the press archive and maybe put a bit less material, less personal data on the internet, searchable part of the internet at that point, at that stage. But what meets this test what goes through, what is legally on the internet according to this test, may then also be equally legally processed by search engines. Okay, so that would be a huge relief for search engines. The mechanism how they reach that result is they take more the fundamental rights of the information providers into account. So here the press. As I said earlier, I think this is correct. We need to take this more into account. The problem is that the Bundesverfassungsgericht claims that this is in line with the case law of the ECJ. Why do they do that? Well, because then they don't have to refer the case to the ECJ. If they would reach contrary elements to the case law of the ECJ, they would need to refer the case there. They say this is not necessary. I don't believe that this is true, because as I told you earlier, the ECJ says those rights override as a rule not only the economic interest of the operator, but also the interest of the ones searching content online. So this is problematic because now we might not get an ECJ decision on this for years. We could have gotten one if the Bundesverfassungsgericht had the case referred to the ECJ. So this system of the Bundesverfassungsgericht could lead to easier decisions, at least in any case for the engine operator. But the question then remains if the Bundesverfassungsgericht diminishes the original responsibility too much of the search engines. And that's an open point for discussion. So where are we at the moment? I would argue that the milestone, this landmark decision of Google Spain, was right in the outset. So search engines need to be responsible for what they do on the internet. They're not neutral proxies in the way they can just sit back and let the other information flow freely, because they do more than just letting information through. They do filtering, they do indexing, they do weighting of relevance, for example. They have relevance criteria. The problem is that there is still no common position, neither in the European Union nor or even less on the international level, on the relationship between these conflicting interests. So if you balance personality rights with information rights, then there's no common ground on the worldwide level. And we have also no common position how we could distribute the responsibility between website operators and engine operators. So we have these four persons, if you want to put it like this, and the responsibility somewhere in the middle. We also don't have common ground on possible side effects, like the risk of overblocking, which is a common problem or commonly addressed here. So if you're Google and somebody requests you to block content and tries to sue you, what would you do if you were Google? Well, you would rather take it off the internet, because the risk being sued by this data subject is a lot higher than the risk being sued by the one who provided the content in the first place, usually at least. There's also no common ground or no position yet on the economic effects. That's maybe one last word on this. This is very interesting, because Google Spain was discussed as being a problem for Google, and Google really fought against this decision. But economically, it might also work in their favor, because as burdensome as these processes dealing with complaints and so on may be, they are possible for Google. Google can hire hundreds of people, no problem, worldwide, dealing with these complaints. But if you're a little startup with a very good idea for a new internet search algorithm, and you think about setting up a new startup, a new website with a search engine, and then you go to a lawyer and he tells you that you need to implement such a mechanism for complaints and so on, and this will work as a barrier to entry this market. So you're not going to start up a new search engine if you need hundreds of people dealing with complaints in the first place. You're going to sell this algorithm to Google probably. And this is a problem. So this could in the end even strengthen Google's position. So one last remarks on ECJ's case law. The ECJ has given us only 3 criteria for this balancing test, and I believe this is not complex enough. The ECJ has unfortunately damaged the system of the protection of sensitive data in Article 9 because of this misinterpretation. And as I said, the ECJ unfortunately lacks a generic system to solve future cases. It was very clear that these further problems would reach the ECJ, and still we needed to wait 5 years for the next decisions. We may need to wait another 5 years if we have until we have another decision on these balancing tests. So I guess that's a lot to discuss. Sorry for taking more of your time than I expected. Thanks a lot for your invitation and for your attention. For those of you who read German, I put a paper of mine that just came out last week. So there might be an English translation at some point, but unfortunately there's not yet. Thanks a lot, and I'm happy to answer questions.
Thank you very much, Professor Hornung. It was a very impressive and very broad explanation, especially the reconstruction of all the details of the Googling decision, the first Google decision, and of course, the last decision of the European Court from last year in the connection with the German cases. Also very interesting, even considering that in the federal court has developed some other criteria, especially this new approach for additional duties for the archive, for the newspaper archives, digital archive is something very interesting. And duty of protection by private actors, maybe it could be a first question we can make. But maybe Fabiano has something to say before that I would really be interested in make some questions.
Ingo, Professor Hornung, Ingo and Gerrit. It was very impressive. I have to thank you, Gerrit, for your lecture here. It was really, really detailed. You went to the points. Very many of the subjects you dealt with are of our concern also in Brazil. I just checked, Gerrit, the domination of Google here in Brazil. It's 96.3% in October of this year. It's impressive. So when you mentioned there at the end is economical effects and some critics that come to the GDPR, to the law, the acts that are made for data protection, that some say they're data protection rules for the big ones. Exactly, but and the small ones. No? So in Germany, we read and heard sometimes Professor Marion Albers, this critic, she exercises criticism to the model of the general rule. Yeah, so general data protection rule. I made many notes here. I had one question for you. If you think that in Europe, maybe in the near future, it will come an act or a law regarding this matter of delisting and the right to be forgotten. I wanted to ask you if maybe this could be a possibility in the context of the e-privacy directive that it's been announced that will, I don't know when, come. And I just wanted to ask you this at this moment, because you mentioned so many collateral effects of this decisions, né? So damages, as you mentioned. And I think this was very interesting how you dealt with the problematics. So I had this to ask. I have many more considerations, but one thing is very important. Professor Ingo Sarlet has a very nice book here in Brazil, Gerrit, about the right to be forgotten. So if afterwards you could hear also you, Ingo, a couple words comparing how we deal with that here in Brazil, that would be also very nice.
I would be interested in that as well. Just very briefly on this issue of new law, I'm not aware of any legislative proposal on the right to be forgotten, neither on the European level nor on the national level. There are many approaches of dealing with internet intermediaries. In Germany, we're struggling with these Netzwerkdurchsetzungsgesetz, so national laws trying to get content out of the internet, which has some severe criminal effects. But that's a purely national issue, and even there, this doesn't apply to Google so far. And I'm not aware that Berlin politicians want to extend that. The privacy directive would be the right point to do this. But the problem is, at least that's my feeling, the e-privacy directive has so many problems already that Brussels politicians will have a lot of discussions still to do to solve the problems it brings about. There was a new approach from the German presidency. So Germany is presidency of the European Union at the moment, and there was a new attempt a few weeks ago, and it might get through somewhere on some point next year, but I don't think we're going to see a Google law in that.
Ingo, do you want to make some comments?
Okay. May I thank you very much. Again, Professor Hornung, thank you for your really nice presentation. And I think, I don't know how, to what extent you are aware of what is going on in Brazil in this field, because of course you have many communication with Brazil, and we also were strongly connected with your data protection laws in Europe, but we have no regulation, specific regulation about the right to be forgotten as well. But we have some law bills in our Congress, but up today without being really finally discussed or enacted. The most recent from this year is one about the law to be forgotten in criminal law, especially in which concern the criminal records of people or proceedings, pending proceedings, but it's also an attempt to regulate at least a partial approach of the right to be forgotten. But we have jurisprudence. Of course, we have court decisions from in all levels of our court system, state system, federal system, even labor law, electoral law. We have, of course, different branches and different, let's say, lots of decisions. But the most important, of course, are the decisions of our Superior Court of Justice, our BGH, and of course, the developments in our Federal Supreme Court. The Federal Supreme Court has no decision, but we have an important case being decided. We had even a public hearing, and the detail is that this case was, in fact, a case which came to the Supreme Court, not related to to a search engine provider, as Google, but offline case. So we call it an offline case, related to two big crimes with a huge repercussion from years ago, and television programs like Lebach case. These were the case was brought to the Supreme Court, but the Supreme Court has chosen to embrace also the online right to be forgotten, and especially the right to de-indexation from search engines, by search providers. But that's interesting
I cannot hear you anymore. Am I the problem, or?
I believe his internet connection has failed.
Yeah,
Probably
I think
still-
Ingo failed, or he's back.
Oh, sorry.
Yes, now we can hear you.
Back? Okay, okay. I think I would be very brief now, because we have these two levels. The first step was the recognition of the right to be forgotten in offline cases, as I said. And these cases are important because we have other cases like this going on. Even the last case decided by our BGH was a case offline, because some of the criteria developed by the court are being used and can be used also in the, let's say, digital domain of the right to be forgotten. One of these criteria, I think, what can be interesting is that it would be possible not to mention the name, the identity of the former accused in a criminal case. Even being released, this program mentioned him by name, and here allegedly he was menaced and so on, and had really big problems with this new TV program. And so the court says, in this case, he has the right to an indemnization, to be compensated financially, because it would be possible for the media not to mention the name, though, of course, presenting the whole case as such. This was an interesting criterion. This criteria was used again by the Superior Court of Justice this year for the last case, also related to this time related to a publication in a magazine, in a journal, about a former crime committed. And the journalist had mentioned the name of the family members of the person who was formerly convicted. And because the mention of the name and the compensation was assured for these people and their family. That's one criterion and one important criterion. The problem is that the online right to be forgotten, the responsibility, the liability of Google and search providers was only recognized in 2018 by our Superior Court of Justice. Before this, there was a complete denial, a strict denial of the responsibility of Google. In this case, we had a decision it was also criticized, and the argument was the court goes beyond that what she really should do to decide the case. And why? Because besides the right to the indexation of the specific link, the court says Google should install filters and differently than the former jurisprudence of the Superior Court of Justice, the court says there is no need to indicate the specific link to be de-indexated, creating a kind of general duty to check and monitor all the information about the reclaimer of the party in this case. So that's the evolution, but as I said, we have only a few criteria being developed. Of course, the importance of the information, the relevance for the historical relevance of the information was also a criteria used in another decision about a torturer during the military regime who was expected to be forgotten. So we have some other criteria, very broadly the same the European Court used in the former Google case. And I think this second criteria, this new criteria of the nomination of the party, and finally the decision of the Superior Court going really, even in my opinion, too far by creating a general duty of monitoring for the search engines. But that's what we have. So we really need more consistency, and that's why decision from our Supreme Court scheduled for this year, for the end of this year, will be so important. So it's very briefly, maybe it allows some other comments from you, Professor Hornung.
Yeah, I find that very interesting because it's another example that we actually do lack consistent solutions, and apparently your courts haven't come up with one either. I would agree with you that these filtering is a separate and more severe problem. As I said, I'm not opposing this notice and take down procedure. I just have problems that the court invented it, that it made it up within the data protection law. I think in general, it's a sensitive approach that you don't put too much burden on the side of the engine operators and not putting them in duty to proactively filter something. Once they receive a complaint and have dealt with it and maybe even granted it, then you can say, okay, then this specific part of information then needs to be filtered from now on in the future. Okay, so this is something different. And it's also the more filtering obligations you put on them, the more the effects on the general public will be. And as you said earlier, I mean, these are still private actors. We could argue how much they should be bound by fundamental rights, but even if we claim that they are directly or indirectly bound by fundamental rights because they are monopolies in the end, yeah. So you could argue that from fundamental rights theory, but even if you do so, they still act as private actors. They want to make money out of this. Yeah? So, and I don't think it's a very good idea to let them decide just by themselves on what content is on the internet and should be.
Yes.
Thank you. Fabiano?
Yes, I just wanted to mention that we had in Brazil this, it came from our courts, the rule of notice and take down, Ingo? And with this act, we enacted in the year 2014, the Marco Civil da Internet. That means like a milestone for internet, this new rule 6 years. Now we don't have notice and take down anymore. We have the necessity of going to a court. Yeah? And this has led to many protests, many complaints in Brazil. And that's also a reason. Many say, Ingo, that it's unconstitutional, this rule of the Article 19 of this Marco Civil da Internet. And this is also going to be decided by the court. I don't know if you want to say also anything on this, Ingo.
I think we should open the floor, give the word to our students, our colleagues. They are following this conference. I think it would be maybe the best thing to do, because we have maybe 15, 20 minutes to finish the presentation, the session.
They can use the chat.
Não, acho que pode fazer, abre o microfone e pergunta. Ou faz pelo chat se não quer se animar a falar em inglês. Ou...
Se quiser fazer pelo chat em português, a gente traduz também, né? Enfim, tudo como quiser. No question? I found it very interesting how the Europeans try to find ways in the GDPR And then when you mentioned, Gerrit, about the consistency mechanism of the Article 63, you managed everything you could with this, because the rule is so detailed, so many, we compare sometimes. Is someone making a question? Okay. And you see, Gerrit, our rules, our law, our data protection law just came into force, except for the sanctions, which are coming to force next year, in August next year. It's not so detailed like the GDPR. We'll have the opportunities in the future when you come to Brazil to discuss more our rule, our law. But I found this interesting how you managed to find ways in your GDPR to find the solutions for the problem and for the problem of solving the praxis. No?
Yeah.
Interesting.
Well, there are lots and lots of problems. I mean, you mentioned our commentary. That's about 2,000 pages, and it's still not all the problems in there.
So about the commentaries, could you? So I saw. I think Nomos, you're bringing a new commentary in the GDPR in English. Is that right?
That's right. Yeah, it's unfortunately it's not going to come out this year. We're aiming at the middle of next year. So yeah, there's going to be an English version. It's not an exact translation, but we're getting more authors from other European states on board. So it's about half of it will be written by German authors, and the other half will be people from all over Europe.
And you are coordinating with whom this project, Gerrit?
I do this with Indra Spieker again. So who does the German commentary with me, and then with Paul de Hert from University of Brussels, and Vagelis Papakonstantinou, who is he wrote his PhD with Simitis actually. He's a Greek lawyer working in Greece and in Brussels.
Very nice, very nice. So Ingo, I don't know if you want to say any more words, if we should.
I would like to ask a question, if that's possible.
Well,
yes, of course.
This is José Renato from the University of Brasilia. It was a pleasure to hear, Professor. Well, here, as you mentioned, this issue of the notice and take down. Here in Brazil, we have been discussing a bill that tries to address fake news and also creates some obligations for social networks to deal with transparency of in their platforms. I would like to know how is the debate about it in Germany, and whether you are discussing also perhaps the implementation of notice and take down mechanisms in your legislation. I know that Germany has already been discussing its hate speech legislation. Well, it's already in effect, if I'm not mistaken. So if you could bring some thoughts about this theme, it would be really good.
Yeah. As I mentioned earlier, and I think that's the law you're referring to as well. We have this Netzwerkdurchsetzungsgesetz, as it is called. That is, it was an attempt a couple of years ago to actually address the hate speech issues. It's not addressing fake news so far, but there is a debate on how it, or if it should be extended to cover fake news as well, because apparently this becomes more and more of a problem. So it doesn't cover search engines. It covers platforms like Twitter, like Facebook, like others like this. You mentioned fake news, you mentioned transparency. Yes, there is a discussion to cover fake news. There's also a discussion on transparency, because in the beginning, after these Google Spain decisions and others, there was no really transparent procedures on how these filtering and how this delisting is being done. Google set up, in Europe, set up a big board of former politicians, data protection officers, and so on. And so Google asked them to come up with some sort of criteria, ideas for processes, and so on, but they were not allowed to review specific cases. And so the extent, I mean, there are figures, you can find figures on the Google webpage, how many cases of filtering had taken place and so on. But there's rather little transparency on the criteria. And that is obviously a problem. So the German Netzwerkdurchsetzungsgesetz also enforced transparency on the providers. So they need to write reports every year on the ways they implement this Netzwerkdurchsetzungsgesetz. So that's one attempt to do that. The other one was, there was this notice and take down procedure in there, but there was not really an effective complaints procedure for the one whose content was being taken down. And so that was a really problem as well, because obviously, I mean, once you only have this one procedure and you're forced to do so, and then you very easily get on this side of over-blocking content. And obviously there are lots and lots of claims for delisting, which are completely without any basis. Yeah? So this happens all the time. People who actually did commit crimes trying to protect their reputation as well. And so that is also a problem. And so now there is a more effective procedure of getting content back on the internet. So I think that's an important thing as well. What we are just starting to discuss, and an issue for which I hope to get funded in a research project in the next years, is the question of artificial intelligence and filtering. So the extent on which these platform operators are bound to use AI algorithms for this filtering, because obviously the amount of filtering that's necessary there cannot be done on a manual basis. This is simply not possible. But then we get this new technology in there, and then we need to concern ourselves how these AI algorithms are being trained. So is it possible, or will it be possible in the future, for AI to detect fake news or hate speech? And then maybe even considering different jurisdictions and different legal views on what is actually hate speech and what is fake news. Even letting out people calling fake news alternative facts. Okay, so even if we let this part of the problem out of the box, then still we have very different views on what is fake news and what is freedom of expression. And so whether or not algorithms will be able to at least help in this decision, maybe they're not taking the decision itself all the time, but helping this decision, I think that will be very interesting in computer science and legal research in the next years.
It was interesting for you to bring that, because I am now conducting research exactly on transparency parameters for dealing exactly with content filtering and social platform search engines and so on and so forth. So yeah, it's a very crucial theme. And here in Brazil, we have started some sort of debate on that, on this issue about how to implement algorithmic transparency in the systems during the debates of this bill. But well, so thank you so much for your thoughts on that.
Thank you for the question. It was very
I
interesting.
would like to, sorry.
And we have another question?
We have one in the chat, and I would like to ask one or two if possible. I believe since I'm helping the professors, I should leave Lais ask first, and then I ask my question.
Okay, so I see the question in the chat, but I have not read it, so I just need to read it. Okay, so this again concerns the relationship between the responsibility of the website operator and the responsibility of the search engine. Well, I would argue if you have a case and if you can make a case to get the content out of the website, the primary website, then obviously this is way more effective. I mean, you have the problem that for a couple of days or a couple of weeks, Google will still provide these results. Because they're still in the index of Google. But that's a problem of days and weeks. And afterwards, it's going to be out of the internet unless there's some sort of internet archive who store this content. But usually Google doesn't index these archives. So obviously, this is a lot more effective. The one of the problems is obviously that there is content out there which is outside your specific jurisdiction. So that was the problem of these German murderer and the New York Times. So then it gets complicated and you need to get to Google. But I think your assumption is right that these local approach could be at least a supplementing strategy because of the limitation of these ECJ approach. We have seen actually, I can add another case, we have seen actually some cases where German courts have ordered Google for global delisting or global blocking. So there is this Max Mosley case, I don't know if you're aware of that, the former Formula One manager who appears to have some sort of sexual orientation involving Nazi uniforms. So there are very nasty pictures about him on the internet there. And these pictures are blankly illegal. There's no reason whatsoever that you could legally process these pictures. And so the problem there is then that these pictures appear again and again. And so the German Court of Hamburg then ordered Google to globally block this content and to filter it when this content appears on other websites as well. But the problem is this is so far restricted to very, very few cases. And so, yes, I would assume that these approach of suing newspaper archives could be one of the reactions or reflex there. The problem then obviously is that courts, I believe, around the world tend to put a lot of emphasis on freedom of the press. So get back to this Spanish article there. I mean, there we had these announcement of these specific case of selling by court order these real estates. I mean, where is the interest of the newspaper in keeping this piece of information, which is 20 years old, on its internet archive? I mean, this was not some sort of political article which you could consider of still maybe being relevant. This piece of information was clearly not relevant anymore, and still it was in Spanish law considered to be part of freedom of the press. So Mr. Gonzalez could not get the newspaper to get this piece of information out of the internet. And I think if you accept this, then this is really getting down to very few cases where you can actually sue the original provider of the information.
Andressa, I think you had a question or not?
Thank you. It was a brilliant and enlightening overview on the topic. And I would like to ask a question regarding content moderation. How do you think private moderation could substitute judicial review on cases on violation of personality rights? And since corporations are binding by fundamental rights, as recognized by the Frankfurt Airport case, judged by the First Senate of the German Constitutional Court, and also a decision from May on the same judicial body on the relevance of Facebook on protecting fundamental rights. The second question I would ask later if there's still time, because it runs a little bit off the scope of your lecture, and I wouldn't like to bother you with some question that is not on scope.
That's no problem. I mean, if any of you has questions related to that and is not being able to ask them that you can always write emails to me. That's the reason why I put my email address on my slide. Yeah, fundamental rights protection. You're right, there is a certain tendency in Germany to put more fundamental rights obligations onto powerful private actors. And we have this Fraport case, so the Frankfurt airport company, the company running the airport, who's actually owned by 3 different state actors. And there was a demonstration in that airport, and the Bundesverfassungsgericht claimed that Fraport is bound by fundamental rights. We have another case, we have 2 more cases actually. Since then, one is a demonstration actually in Passau, in front of a supermarket, which I used to buy my food in. And that's a public place, and you are able to access it publicly, but it's owned by the supermarket. And the supermarket wanted to kick off poor people who were sitting there from there. So it wanted to have a clean space, and somebody wanted to demonstrate that somebody happened to be a member of staff of a colleague of mine in Passau. And he wanted to make a beer demonstration because people were not allowed to drink beer there. So they wanted to make a beer demonstration. Everybody was asked to come there, bring a bottle of beer and drink a bottle of beer together to demonstrate against this supermarket. So they were not allowed to do so. They sued before the Bundesverfassungsgericht, and they got through. You can see a video of the beer demonstration on the internet. And because Bundesverfassungsgericht said, well, this supermarket may be a private company, but this is a public space. And people who are just walking by would not even assume that this is privately owned. So the supermarket needed to allow that. And the third case is actually dealing with football and concerns the legal boundaries of football teams to not let people into their stadiums. Also there, the Bundesverfassungsgericht showed a tendency to put fundamental rights obligations on those private actors, the criteria for which are still not so clear. And we haven't seen yet a case where this line of argument is being applied by the Bundesverfassungsgericht on powerful internet companies. I would assume that it's perfectly logical to do so in case of powerful monopolies or oligopolies. I would consider it perfectly conceivable to argue that the moderator, to come to your question, the moderator of an internet discussion forum should at least be indirectly bound by fundamental rights if it happens to be Facebook or Instagram or providers on that scale. The problem then obviously is what follows from that, but because they are still private actors and they still enjoy fundamental rights themselves, and the private policy might be very different on the issue of filtering or not filtering, because that might be in forum which actually is meant for discussions, and so that also happens there. We have a huge discussion in Germany, actually in the lower courts so far only, on the boundaries of these moderating policies. There's still no high court decision. There are courts who argue that a moderator may only, or the filtering policy in moderation may only leave content out which is illegal according to criminal law. So unless you insult somebody to an extent that it's a crime, inflammatory crime, then you have to be allowed to say that, even if it's gross criticism. And there are other courts who say, well, this is criminal law. This is the very outset. So in our general terms and conditions, the internet providers of these discussion forums are allowed to a certain extent to narrow this down and to kick people out because of what they post on the internet, even if that doesn't amount to a crime. So these are just two positions in German lower courts at the moment, and we have to see what the high courts make out of this.
Perfect. Thank you very much.
Oh,
Close, né?
now, so vamos encerrar, né?
Thank you very much, Gerrit.
No, thank you. I forgot to mention in the beginning that I was about to come to Brazil this spring, which didn't work out for reasons known to everyone. And I very much hope to be able to do that next year or maybe the year afterwards, and to see all of you in person in Brazil.
Yeah. Ingo will close now our meeting. And
okay, Professor Hornung, thank you very much again for your really brilliant speech. I was following the comments from our students. Everyone is very satisfied about the conference. We have recorded the session. I don't know if you allow this or not. If you allow, it will be only used for educational purposes for the students and colleagues, not public broadcasting of the video, unless you accept this as well. But it's really up to you, of course, to give this authorization or not, or maybe the slides can be very useful for our students. We have several students working on data protection, on content moderating in the internet, and so on. And I will thank all the students, all the colleagues. They're following the conference with us. Fabiano Menke for his help and for his constant partnership. We have a colleague, also a civil law colleague who studied in Regensburg, did his doctorate in Regensburg, Professor Fabio Andrade. We have also other colleagues from other institutions here, and I would also thank the students from Laura Mendes from the Brazilian Institute for Public Law. They are following the conference, and I really hope to see you. We all hope to see you personally as soon as possible. Coronavirus should allow us this, or at least vaccination. In spite of Bolsonaro's view of not vaccination the population, in spite of this, I think everything will go well next year. Thank you so much. Já foi? Já foi, né?
Bye. Thank you very much.
Bye-bye. Thank you.
Thank you.
Bye-bye. Wiedersehen. Tschüss. Dankeschön.
Tschüss, Bye.